Start. This is an application for condonation of delay of 78 days in filing the main appeal. Stop. For the reasons stated in the application, the same is allowed and the delay of 78 days in filing the main appeal is condoned. Stop. The present appeal has been preferred by the claimant appellant aggrieved by the quantum of compensation awarded by the Motor Accident Claims Tribunal Fatehgarh Sahib wide award dated 27 March 2017. Stop. Since the factum of the accident is not in dispute, the facts as recorded in the impugned award passed by the tribunal are not being adverted to herein for the sake of brevity. Stop. Learned counsel for the claimant appellant would contend that the claimant appellant does not challenge the multiplier of 5 as applied by the tribunal. Stop. Learned counsel, however, states that the income of the deceased, who was a homemaker, was assessed as rupees 5,000 per month, whereas the same ought to have been done on the basis of the minimum wages applicable to a skilled worker at the prevalent time, that is 9,245 per month, and has relied upon the judgment of the Honorable Supreme Court in the case of Kirti and another versus Oriental Insurance Company Limited. Stop. It is further the contention of the learned counsel that there are 8 children of the deceased, the claimant appellant herein, and that no amount has been awarded under the head of loss of consortium. Stop. Learned counsel would further contend that the amounts awarded under the conventional heads are not in consonance of the law laid down by the Honorable Supreme Court in the case of National Insurance Company Limited versus Pranay Sethi and others. Stop. Per contra, the learned counsel for the respondent number 3 insurance company has vehemently argued that sufficient amount had already been awarded as compensation in the present case, and that there is no scope of any enhancement. Stop. In the present case, the argument of the learned counsel for the claimant appellant that the income of the deceased should have been assessed as per in minimum wages of a skilled worker deserves to be accepted. Stop. The Honorable Supreme Court in the case of Kirti, while assessing the notional income of a homemaker, has held as under. Stop. Therefore, in the basis of the above, certain general observations can be made regarding the issue of calculation of national income for homemakers and the grant of future prospects with respect to them for the purposes of grant of compensation, which can be summarized as follows. Stop. Grant of compensation on a pecuniary basis with respect to a homemaker is a settled proposition of law. Stop. Taking into account the gendered nature of housework, with an overwhelming percentage of women being engaged in the same as compared to men, the fixing of national income of a homemaker attains special significance. Stop. It becomes a recognition of the work, labor, and sacrifices of homemakers, and a reflection of changing attitudes. Stop. It is also in furtherance of our nation's international law obligations and our constitutional vision of social equality and ensuring dignity to all. Stop.